Hello, it's Jerry Davison. Giving an employee shares in a company is one way a business can incentivize employees and align their interests with those of the company. However, there are certain company and tax law issues that need to be considered before you progress down this route. An important thing to remember is that once an employee holds shares, they are a shareholder in the company, and therefore the ownership of the company is diluted from day one. The employee may also have a say in the running of the company, depending on what rights are attached to the shares they hold. Someone once said that legally, a company is really just a pile of documents. This is because an incorporated business is an artificial construct and not physical like its employees or offices. A company is owned by its shareholders who invest their money in the company and take a risk that if unsuccessful, they will lose that money. The pile of company documents starts with the constitutional rules, the Articles of Association, and maybe a shareholder agreement, and they specify the rights and duties of shareholders and directors. Then you have shareholder registers, employment contracts for the staff, leases for the offices, contracts with the suppliers and customers, and of course a myriad of other documents such as any patents and banking agreements, for example. In addition, all UK companies are governed by various statutes, the main one being the Companies Act. The shareholders, as owners, delegate the day-to-day management of the company to a board of directors. Of course, some or all of the board may also be shareholders as well. And this is where the duties and responsibilities of directors are so important, because a director must act in the best interests of all shareholders and avoid any conflicts of interest. They have a duty to act in the best interests also of the company and its employees, customers and suppliers, as well as the owners. Directors can be fired by shareholders as well as by a majority of the board. So what about shares? Well, most shares are ordinary shares which have specified rights of voting, dividends and capital distributions and so on. You can easily set up different classes with differing rights. For example, B ordinary shares, which could be non-voting and subject to buyback if the shareholder is an employee and leaves the company. Other types of shares, such as preference shares, are not quite so common these days. If a venture capitalist or business angel invests in the company, they may require a different share class, such as Series A shares or seed shares, and these would have special rights. The value of shares. A company could be worth £10 million, but have share capital of only £100, perhaps 100 ordinary shares of a pound each. This is the nominal value of the shares when they're originally issued, and the ownership of these shares determines the percentage anyone owns in the company. So if someone owns 40 of the 100 shares, then they own 40% of the company. You may have heard of a share split. Well, very often it will be necessary to effect a share split to allow small percentages to be granted under an EMI options scheme, for example, much more easily. For example, the 100 £1 shares above could be split into 10,000 shares of 1 pence each. Because new shares are normally issued when EMI options are exercised, the option shares will be accounted for by grossing up the issued shares. For example, if options granted totaled 20% and there were 10,000 issued shares already, then you would need 2,500 extra shares for the options, so that when employees exercise all their options, there would be 12,500 shares issued. And of course, 2,500 shares issued divided by the 12,500 shares total is 20% of the entire share capital. Thanks very much.